Welcome to this deep dive. And if you are joining us today, you are exactly where you need to be.
Absolutely.
Whether you are prepping for a crucial meeting or studying up on the structural foundations of the government, or, you are just insanely curious about how power actually operates behind the scenes, you are in the right place.
It is the right place to be.
Our mission for this session is to unpack a dense, 1803 legal showdown, one that is, without exaggeration, the single most important foundational moment in American law. We are looking at the Supreme Court case, Marbury v. Madison.
Yeah, that's the one.
And we are going to bypass the dry textbook summaries you might have encountered in a high school civics class. Instead, we are going to look at this for what it truly was, a masterful, high-stakes political chess match.
It really is. It is the defining moment of the American judicial system. When you look at the raw notes and the historical context surrounding this ruling, it stops being a dusty legal document. It becomes a thriller about the absolute limits of executive power, the survival of the courts, and, well, what happens when bitter political rivals collide.
To understand the sheer genius of what Chief Justice John Marshall pulled off here, we have to look at the incredibly messy political transition that sparked the whole thing.
Oh, it was a mess.
The year is 1800. John Adams, a Federalist, has just lost the brutal presidential election to Thomas Jefferson, a Democratic Republican. It is the first time in American history that power is transferring from one rival political party to another.
And the Federalists are terrified they're about to lose everything.
Completely terrified. So in the waning lame duck days of his presidency, John Adams and his Federalist Congress pass a new Judiciary Act, creating a whole bunch of new court positions.
It's out of nowhere.
Adams then stays up late into the final nights of his presidency, rapidly appointing his own party members to these new judicial roles. History literally calls them the Midnight Judges.
Because it was a blatant attempt to pack the courts. They wanted to maintain a stronghold on at least one branch of the government before Jefferson actually took office.
Right.
And this is where the logistical nightmare begins. Adams nominates these judges, the Federalist-controlled Senate confirms them, and Adams signs their official commissions.
But a commission isn't official until the Secretary of State affixes the Great Seal of the United States to the physical paper and delivers it.
Exactly. The physical delivery.
And here is the ultimate historical irony that makes this entire situation so absurd. The Secretary of State, who was frantically stamping these seals and trying to deliver the paperwork before the clock ran out on the Adams administration,
Was a man named John Marshall.
was John Marshall, the very same John Marshall who Adams had just appointed as the new Chief Justice of the Supreme Court.
Talk about a conflict of interest.
He was pulling double duty. And in the chaotic final hours, Marshall simply ran out of time. He left a stack of these fully signed, sealed commissions sitting on a desk in the State Department.
Which brings us to the inciting incident of our deep dive. Thomas Jefferson is inaugurated. He walks into the executive branch, finds this stack of undelivered Federalist appointments on a desk, and essentially tells his new Secretary of State, James Madison,
Do not deliver these.
right, he says, do not deliver these. Jefferson wants to stop the court packing dead in its tracks. And one of those undelivered pieces of paper belonged to a man named William Marbury, who had been appointed as a Justice of the Peace in Washington, D.C.
Okay, let's unpack this. Because the sheer drama of the situation is fantastic. Marbury wants his job.
Yep.
He was promised this position. The paperwork was signed by the president. It was sealed, but he never actually received it in his hands. So he sues James Madison to force him to hand over the paper.
He wants his commission.
When you look at the core of Marshall's ruling, the very first question the Supreme Court has to answer is deceptively simple. Does William Marbury actually have a legal right to this job?
And to resolve that, Marshall meticulously breaks down the exact anatomy of a presidential appointment based on the text. It is not just one sweeping action. It is a sequence of distinct constitutional operations.
Okay.
First, you have the nomination, which is the sole voluntary act of the president. Second, you have the appointment itself, which requires the advice and consent of the Senate.
Right, the Senate has to agree.
But the pivotal milestone, the absolute point of no return, is the president's signature on the commission.
Well, wait, let me play devil's advocate here for a second. In almost any standard contract, if I agree to sell you my car and I sign the paperwork, but I never actually hand the title over to you or deliver the vehicle,
The deal isn't fully executed.
right, the deal isn't done. Why is the Supreme Court treating a government appointment differently than a standard transactional contract where physical delivery is required?
It is a great question. And it is exactly the vulnerability Jefferson was trying to exploit. But Marshall closes that loophole by separating the political act of the president from the administrative duty of the state. He argues that the power of the executive over an officer has to cease at some specific, definable point in time. That point is when the constitutional power of appointment has been fully exercised. The absolute last act required from the president is the signature.
Okay, so once the president signs that commission,
His judgment is made. The time for deliberation has passed. The signature is a warrant for affixing the Great Seal, and the seal attests to the absolute verity of that signature.
Marshall uses a brilliant analogy to hammer this home, pulling from real estate law of the era. He references a 1796 act regarding the sale of federal lands above the mouth of the Kentucky River.
That's right.
The logic is that once a purchaser pays the money and produces the receipt, the president is authorized to grant a patent. That land patent is countersigned by the Secretary of State and recorded in the government ledgers.
And the connection Marshall draws there is unshakable. If the Secretary of State simply chooses to withhold that physical land patent, or if the paper is lost or burns in a fire, the purchaser doesn't magically lose the land.
Right, they bought it.
Exactly. The official record in the government office is proof enough. The physical paper in your hand is merely evidence of the right. It is not the right itself.
So Marshall is saying that the actual transmission of the commission, the physical handing over of the paper, is just a practice of convenience. It is not a legal requirement to constitute the appointment.
No, it's not.
Because the Office of Justice of the Peace was created by a special act of Congress for a term of 5 years, Marbury's legal right to that office was permanently locked in the absolute second the seal was affixed.
Precisely the foundation of the ruling. Transmission is just a convenience. Marbury is legally entitled to the job for those 5 years. But establishing a right is only half the battle.
Right, the next logical step. So Marbury has a vested legal right, but does the law actually provide him a mechanism to fix this? Or is he completely out of luck because the person holding his paper hostage happens to be a high-ranking politician?
If we connect this to the bigger picture, this is where we get into the bedrock of legal theory. Marshall reaches back to English common law, specifically leaning on William Blackstone's commentaries.
A huge authority at the time.
Massive. Blackstone lays out an invariable principle that forms the basis of modern justice. It is a settled principle that where there is a legal right, there must also be a legal remedy whenever that right is invaded. You cannot have a right without a mechanism to enforce it.
This leads to one of the most famous declarations in the entire ruling, and really in American history. Marshall states that the United States is emphatically termed a government of laws and not of men.
A government of laws and not of men.
And he warns that it will absolutely cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right.
But there's a vital nuance regarding the nature of executive power here that Marshall has to navigate. He distinguishes between a political act and a ministerial act.
Because if the courts can just order the president's cabinet around, that violates the separation of powers.
Exactly. Marshall openly acknowledges that the president is invested with certain important political powers. When the president is using his constitutional discretion, like conducting foreign policy, he is accountable only to his country in his political character.
So courts can't touch that.
Right. The courts have absolutely no jurisdiction to look into acts where department heads are acting purely as political agents of the president. But when the law assigns a specific duty that affects an individual's rights.
Like recording and delivering a valid commission.
Exactly. In those specific instances, the department head is an officer of the law. They cannot just, at their own discretion, sport away the vested rights of others.
I love that phrase from the text, sport away. It paints such a clear picture of arbitrary power. And for you listening right now, this distinction is why this 1803 decision is so deeply relevant to the society you live in today.
It really is.
It establishes the precedent that absolutely no one in the government, not even a presidential cabinet member, is entirely exempt from legal investigation if they violate an individual's rights.
It is a profound check on executive overreach.
Here's where it gets really interesting. So Marbury is legally right, and the law says he deserves a remedy. But knowing early American politics, Madison didn't just hand it over after a polite request. What specific legal weapon was Marbury using?
Marbury was asking the Supreme Court to issue a writ of mandamus. Marshall cites Lord Mansfield and Blackstone from the text to define this. A writ of mandamus is direct command to a government officer to do a specific duty.
It is the court pointing at a government official and saying, do your legally mandated job.
Precisely.
And Marbury wasn't just guessing that the Supreme Court could do this. He had a specific law on his side. The Judiciary Act of 1789, passed by Congress, explicitly authorized the Supreme Court to issue writs of mandamus to public officers.
Yes.
So, if we look at the board, Marbury has a right to the job, there is a remedy, a writ of mandamus is the perfect remedy. And an act of Congress expressly says the Supreme Court has the power to give it to him. Open and shut, right? The court should just issue the order.
This raises an important question. And we encounter the massive jurisdictional roadblock that defines this entire case. Marshall pivots away from the act of Congress and looks directly at the United States Constitution itself.
The ultimate rule book.
The Constitution explicitly outlines and restricts the Supreme Court's jurisdiction. It divides it into original jurisdiction and appellate jurisdiction.
For those catching up, original jurisdiction means you are the court of first resort. You hear the case for the very first time. Appellate jurisdiction means you are simply reviewing a decision that has already been made by a lower court.
And Marbury tried to skip the line. He went straight to the Supreme Court because the Judiciary Act of 1789 said he could.
Right.
But the Constitution strictly says the Supreme Court only has original jurisdiction in specific cases, like those involving ambassadors, other public ministers, or states. For everything else, it has appellate jurisdiction.
Marbury is not an ambassador. He is not a state. He is just a guy trying to get his justice of the peace paperwork.
Therefore, Marshall connects the dots for the listener. Issuing a mandamus directly to a public officer like the Secretary of State to deliver a paper is an act of original jurisdiction.
Okay.
Because this scenario doesn't involve an ambassador or a state, the Constitution says the Supreme Court only has appellate power here. They can't act as the court of first resort.
So we have an explosive contradiction. Congress passed a law giving the Supreme Court a power that the Constitution expressly didn't give them.
That is the crisis point.
So what does this all mean? What happens when an ordinary law passed by Congress directly conflicts with the Constitution? Which one survives? Because Marshall is essentially looking at a lose-lose situation here.
He is completely boxed in.
Right. If he orders Madison to deliver the commission, President Jefferson will ignore the order. The court has no army. That would destroy the court's legitimacy. But if he backs down, he surrenders to his political rival.
This is where Marshall's political genius shines. He delivers Chief Justice Marshall's legendary conclusion. He declares that the Supreme Court cannot issue the writ because the law Congress passed giving them that power is unconstitutional.
Wow.
And in doing so, he drops the most consequential sentence in American legal history. He says it is emphatically the province and duty of the Judicial Department to say what the law is.
So he sacrifices Marbury's job to permanently cement the Supreme Court's power over the other two branches.
He gives up a tiny short-term battle to win the ultimate long-term war. And his philosophical defense of this power is impenetrable. He breaks down the logic of written constitutions.
Okay, let's hear the logic.
The whole point of the people writing down a constitution is to limit government power. If the legislature can just pass an ordinary act that overrides the Constitution, then the Constitution is on the same level as any everyday law.
It would make a written constitution an absurd attempt to limit a power that is essentially illimitable.
Exactly. An absurd attempt.
To ensure this sticks with you as a listener, we have to bring in the wild hypotheticals the Supreme Court used to prove their point in the text. Marshall forces us to grapple with high-stakes scenarios.
The treason example is incredibly vivid.
Yes. The Constitution explicitly states that no person shall be convicted of treason unless on the testimony of two witnesses. It requires two witnesses to the same overt act. What if Congress passed a law allowing someone to be convicted of treason with only one witness?
Must the constitutional principle yield to the legislative act?
Right. Or what if Congress put a tax on exported cotton or tobacco, which the Constitution explicitly forbids? If the courts have to close their eyes to the Constitution and only look at the laws Congress passes, they would be forced to uphold illegal taxes.
Or worse, they would be actively participating in a constitutional violation by condemning innocent victims to death based on a legally invalid standard for treason.
Which brings up the final nail in the coffin.
The oath.
Yes, the oath.
Every judge takes an oath to discharge their duties agreeably to the Constitution. To force them to knowingly violate it by upholding an unconstitutional law would be a solemn mockery.
A solemn mockery and a crime.
Therefore, any law repugnant to the Constitution is void. Any law that violates it is simply not law. Marbury doesn't get his mandamus from this court because the law allowing them to do it is unconstitutional.
It is incredible to step back and look at the massive architectural shift we've explored today. We started with William Marbury complaining about a missing piece of paper, and ended up with the Supreme Court declaring it has the ultimate authority to strike down unconstitutional laws.
He took a vulnerability, a mundane administrative oversight, and transformed it into the very foundation of American constitutional law.
And for you, as you synthesize this deep dive, consider its immediate relevance. Every single time you hear about a law being challenged, debated, or overturned by the courts today, you are watching the echoes of this exact 1803 decision play out in real time.
It is the active, functional operating system of the government.
It really is. It's not just history.
As we wrap up this analysis, there is a final thought to mull over, drawn directly from the text's dire warnings. The text argues that if courts had to ignore the Constitution and blindly enforce any law passed by the legislature, it would give the legislature a practical and real omnipotence.
The practical and real omnipotence.
Think about that as you navigate today's world of nonstop legal and political debates. What would our society actually look like if the government could simply pass any limit at its own pleasure, and the foundational rules of the nation were nothing more than mere suggestions?
That is a profound tension to carry with you. Thank you for joining us on this deep dive. Keep questioning the structures around you, keep exploring the hidden forces that shape our world, and we will catch you next time.